Quickie! The Supreme Court's free speech protections in Sullivan were further refined in Garrison v. Louisiana. New Orleans DA Jim Garrison was criminally convicted of libel because he had complained that the backlog of criminal cases was due to the inefficiency and laziness of 8 state judges. He also said they got in the way of him enforcing the law. This ran afoul of a Louisiana statute making it criminal liable to make false and malicious statements against public officials, or to make malicious statements that are true and made with, quote, hatred, ill will or enmity, or a wanton desire to injure. The law had rejected truth as a defense, something that's been precedent since before the founding of the country. It also didn't place the burden on prosecutors to prove that the comments were made with actual malice. The Supreme Court also said that malicious statements made against public officials were still protected under the First and 14th Amendments, even if they were false and made with ill will. It's just that important to be able to speak out against public officials. They also didn't like that this was a criminal penalty, not civil. But they didn't close the door to it entirely. They left open the use of calculated falsehoods, and Justice William Brennan wrote, although honest utterance, even if inaccurate, may further the fruitful exercise of the right of free speech, it does not follow that the lie, knowingly and deliberately pushed about a public official, should enjoy a like immunity. Douglas and Black disagreed in their concurrences, saying in Black's words, under our Constitution, there is absolutely no place in this country for the old, discredited English Star Chamber law of seditious criminal libel. One day, maybe a future Supreme Court will agree and do away with criminal libel altogether.